This is an article I pulled from Fox Business, which I think is basically a repost from a New York Post or something like that. Anyways, I'll post the first sources I can find on this article. And this is discussing Subway franchisees and some of the new rules that are being imposed upon them that they're not happy about. So I am a franchise attorney, so this was very interesting to me, and I thought I would share some of this with our audience and with our clients or prospective clients who listen in on Odyssey here. So what the major changes in the Subway franchise agreement that are coming around now is that stores are not allowed, this is the major one that they highlighted in this article. Stores are not allowed to close more than once per year without permission or an act of God that prevents them from opening. Now, if they don't adhere to this, if they close for more than 1 day per year, they could be at risk, obviously, of termination. But also the article states that they could be taken over by the franchisor. And taken over, there's not really any details on that here, but that could either be taking the unit completely, like the ownership aspect of it, or what I think is more likely is that they could take over the operations, so that the franchisor takes over operations and gets a fee for that, basically. They run it, you still own it, but the franchisor will operate it on your behalf and give you whatever profit is made after they get their new fees and such. So there's no details on that. Now, that is typical. That's not something, I see that all the time in the franchise industry. I would say that that's not something completely unusual in the franchise industry. From what I understand in this article, this is the first time that the franchise agreement for Subway is changing in 20 years. So I get that people aren't happy about it. Now, after 20 years, you see all these new terms that seem rather onerous. The Subway leadership team explained this as they're bringing their franchise agreements into kind of the 21st century, into harmony with other industry standards and other franchise agreements that their competitors have. I would tend to agree with that, but I think they're doing it rather in a harsh way, unfortunately. And what it sounds like is that the franchise agreements are for 20-year terms, and that the ones that are expiring will now have to sign these new franchise agreements and these new terms. One thing I want to mention is that I don't see a lot of franchise agreements for 20-year terms. Some of the bigger franchise systems do, but 20 years is a long time. And I've had this exact conversation with franchisees who are about to sign a 20-year franchise agreement. And really, the conversation when I knew that my client who's looking at this was probably a year ago or two, had recently had children, and we were talking through the timeline, and I told him, well, just understand, this is a very long franchise agreement. I know you just had a child. Think about it. By the time you are finished with this franchise agreement, your child will be grown and probably almost out of college, right? They will be out of the house, hopefully. And that's just really amazing, right? When you think about it that way. I feel like I've seen one that was even 25 years, and it's just crazy. That's like a quarter of a lifetime or more, for most folks. So 20-year term is a lot. I probably wouldn't encourage clients to jump into that unless you have a solid exit plan, right? Unless you know you can sell that unit. Just 20 years to be contractually obligated to anything is crazy. I mean, I guess people sign mortgages all the time, right? So maybe it's not a big deal, but operating a business under a 20-year contract is quite a bit different than paying your house note. So 20-year terms, let's see. Other terms, let's touch on this first. So other terms in the agreement is that no negative comments can be made about Subway in any forum. So this has become popular, I think, in the franchise industry, including some form of that type of provision in a franchise agreement. I am of the opinion that this is probably not enforceable in many states. There are already several states who will require that type of language to be struck from the franchise agreement. Washington State comes to mind in particular. I think California does. I have to double check on California. Probably Illinois as well. But anyways, I think in many states, depending on what you write if it's factual and it's not demeaning or defamatory, that clause is probably not enforceable. You can always go say, Subway is making us do this, X, Y, Z, and it's causing us to lose sales, right? That's probably acceptable. Subway will not be able to force you, in my opinion, to not be able to say that. So I kind of have mixed feelings on that term there. I think it's, whether they're going to use it or not, it's probably not. But I get why it's there. So I don't think that's as big of a boogeyman as they're making out in this article. Let's see, what's next is no using Subway's name on franchisee websites or email addresses without permission. That's totally typical. You can't use a trademark name unless you have permission from the owner. Franchisees that leave the system prematurely must pay royalties for 3 years based on the prior year's average. That is a liquidated damages clause. That is totally normal these days. I don't like them. I try to negotiate out of them or negotiate around them, or at the very least limit them either by time or money or something. I don't like liquidated damages just in general, but I get why they're there. Even my franchisors have liquidated damages. So, and we've had to use them actually. So I'll say that. The only time that liquidated damages is truly ever levied, in my experience as a franchisor's attorney, when we do it is when there is a bad actor, when somebody has obviously broken the franchise agreement and has done it maliciously or lied to us about something, concealed sales, and then they're trying to get out of the deal or something. There's usually a lot more behind it than just somebody walking away from the franchise system, and then we have to hit them with liquidated damages. I've had some franchisee clients though have to negotiate out of liquidated damages after the fact whenever they're trying to exit a system. And from that perspective, when we had to do it, it was purely an economic decision to close down, and we were able to really, sometimes we were able to get out of them completely, other times we were able to limit them quite a bit. So again, it's very typical. It's not the biggest boogeyman out there. In my opinion, I don't like them, but it's there. They're out there. You just got to know how to deal with them. Let's see. So other terms in the agreement is that Subway corporate will control the hours of operation and the pricing. So hours of operation, again, that's typical in the franchise industry. I don't see why that's a big deal. Now pricing, that gets a little iffy, because if they are mandating specific prices for the bulk of their menu, they could run afoul of SBA rules. And SBA, in particular SBA financing rules, where the SBA will not certify that franchisee as a small business, and then they won't be able to secure SBA financing. So I don't know, just from what I'm reading here, I can't tell you if that's the case or not, but that's always a factor in working with franchisors of how much control we have on the pricing. Is we have to understand the ramifications of that for our franchisees getting financing. You also now will have to pay $150 a month for, the rights to Subway's digital menu board. That, again, this is stuff that I see quite often. If you're using some type of a digital subscription service, you're gonna have to pay for it. This is obviously, Subway has some type of a digital menu board subscription service that they're mandating. Totally in the norm for franchise agreements. I don't see why it's such a scary thing. And lastly, franchisees will have to give furniture, signs, or material that says Subway back to Subway corporate, even though franchise may have paid for it at the end of the relationship. This is typical. There's nothing unusual about that. I don't get what the deal is. If you have something that says Subway on it, it is branded and trademarked with somebody else's trade name, trademark, logo, whatever, they should have the right to be able to determine what happens with that, right? Now, I don't know, I haven't read their new franchise agreement. I probably won't have access to one for a while, but they'll have to disclose it publicly, so or at least in a couple states. So maybe we'll do a video revisiting it and looking at it. But anyways, it's not that scary. So probably what the franchise agreement says, and this is very typical, very standard, is that if you have anything branded with our trademark, our name, whatever, you have to give us back anything that has our name on it, but we will pay for it at cost or some type of a calculated depreciation. It's not usually that they just come and take it from you. That's obviously still your property. Taking it is theft, right? Unless there's some type of a compensation for that. So I doubt that it's just somebody taking your furniture that says Subway on it or whatever. They have the right to be able to control stuff that has their brand on it. And really, the way I explain this is if there's some type of secret sauce, something that makes your franchise system unique, and it's something like a device or some type of equipment, you as a franchisor, you don't want that equipment ending up on eBay, right? You don't want it being sold on Amazon. So that type of stuff needs to go back, and it will go back to the franchisor, because that's what has to happen to protect the franchise system, protect the secret sauce, whatever. But so I don't know. I think there's some misunderstandings from the author of this article, and maybe some hyperbole from the franchisees even. Let's see. So repercussions: if the franchisees do not agree to the new franchise agreement, they will face a new 10% royalty. So what this is saying is you're coming up on the expiration of your existing franchise agreement. Here's the new one you got to sign. Or if you don't, you can renew, but you're renewing under the old one, but we're going to change your royalty to up to 10%, which is pretty crazy. 10%, I don't ever see in a food chain at all. Highest would be like 8%. But food and fast food in particular are notorious for small margins. You make it up obviously in volume. So it's very unusual to see 10%. And that will probably make some people's Subway franchise units uneconomical and unfeasible to continue. So they're probably pushing some people out of the system. Now there is some discussion here about why this is happening potentially right now. It notes that there is a new owner that bought the Subway system, the franchisor, that is, it bought the franchisor's part of the system in 2019, and they've been trying to cut costs. I don't know who this is. It's what, Chidsey? I don't know who that is. Some kind of a private equity group, I'm sure. Private equity has been a bane to the franchise industry. They've been very, I don't want to paint them all as bad, but they've done a lot of harm in a lot of systems, and I've battled them in some situations. So I'm not a big fan of private equity moving into the franchise industry. That's what it looks like here. They're saying they're cutting costs. They've moved operations to Florida from Connecticut. Obviously, that's probably where the private equity owners are living, right on the beach. So you're gonna move your business there. And it is suspected that they're trying to make the company more attractive for a sale, and that would be very prototypical for a private equity process. They're gonna buy it. They're usually highly leveraged, and they're gonna trim a bunch of fat. They're gonna cut as much as they can out of that business, and then try to flip it and sell it. It's kind of like, it's almost exactly what real estate flippers do. Some of the more less trustworthy house flippers, that they'll buy a dump, they'll put some makeup on that dumpy home and make it look a little bit better, and then flip it for a multiple higher. And all the underlying problems probably still exist, right? They didn't really fix anything. They just made it look pretty. That's kind of what private equity does in the franchise space. So not a fan there. One consultant commented in the article here, says that he expects most to end up paying a higher royalty rate than agree to the new terms. This is where I disagree. I think that most franchisees, if they think long and hard about it, if they look at comparative systems, they'll understand that most of the franchise agreement is probably very typical in the industry, and it's not as big of a boogeyman as they think. And then hopefully they'll do their numbers. Hopefully they'll look at it from a business perspective and understand that a 10% royalty is probably going to make them unprofitable. I don't know that for a fact, but that's probably at least doubling their royalty fee, I would have to say. And that's, I don't know, if you can be profitable with it, great, but it's going to be a lot of folks who aren't going to be profitable. So lastly, there's one more thing that they mentioned, that a franchisee was complaining, saying that it's going to kill their chance for the sale of their franchise units. Again, I disagree here too. Now, Subway is a system that has problems. Obviously, they're oversaturated in many markets. So yes, not all franchise units will be sellable, will be an attractive purchase by buyers. But just because they have new franchise terms that are rather typical in the industry, I don't think that's going to kill your sale price or your sale of your franchise unit. May make it a little more difficult, maybe. People will think a little bit harder about it, but honestly, if they're comparing this to like a Wendy's or a McDonald's or something, the terms are going to be probably substantially similar. I can't imagine they're going to be much different. Where the difference will be is if you got to pay a 10% royalty, that's for sure. And the last comment, rounding it out, is just note that in the last 3 years, 14% of units have closed in the Subway system, which is a lot. So just again, Subway systems had a lot of hurdles that they've had to stumble over this last few years. Of course, the Jared situation being one of them. They've oversaturated. That's just a plain fact. There's just too many Subways out there right now, and they're going to have to consolidate and close some, probably to get back to profitability. And then also the fact that the sandwich shop space is super competitive right now. They got Jimmy John's. There's like what else is out there? There's Firehouse Subs. There's Quiznos isn't around, but there's Slotsky's. There's all sorts of other sandwich shops. I'm missing a bunch of them, but anyway, super competitive, and it's hard to really distinguish yourself because everybody toasts them now, right? Everybody has deals on bigger sandwiches. Everybody has kind of the same ingredients in general. There's only so much lettuce and tomatoes and black olives you can add or cucumbers to a sandwich. So I think they're going to struggle in the future. I don't think they're going to disappear. I like Subway. I go there, but they're going to have a hard time. They're going to have a hard time in the next few years. So think hard about whether Subway is the right investment for you, I think. So that's all. Just want to comment on that article. Again, if you have any questions or looking to purchase or sell a franchise or thinking about franchising your concept, reach out to Reidel Law Firm. There's more details in the description below, and look forward to hearing from you.